again, Your Honors.
Good morning.
Gerder, on behalf of the appellant, Mr. Mosley. May I again reserve 4 minutes for rebuttal, please? Thank you, Your Honor. In this case, in a briefs, we have asked this court to reverse for 7 reasons. I will plan to only address 2 today, unless the court has questions on any of the ones that I do not get to. But for purposes of today, I'd like to focus on Mr. Mosley's right to a speedy trial and the self-defense argument. Regarding the right to a speedy trial, the point that I mainly want to emphasize today, because I do think everything is more than adequately briefed by both sides. But on the speedy trial issue, I wanted to emphasize that Mr. Mosley was pro se for trial and for a good bit of time pre-trial. And the big question in speedy trial claims is prejudice, whether there was prejudice. That is normally what those claims boil down to. Mr. Mosley, as a pro se defendant, perhaps more so than usual, was prejudiced by the delays in this case because that increased his anxiety and concern about the evidence that he knew and then was rightfully shown to be was missing. And so just, I wanted, that is all laid out, the timeline is all laid out in the briefs, but I did want to emphasize Mr. Mosley repeatedly told the trial court, I am missing evidence, there are more videos. The state kept saying, this sort of relates to our discovery discussion earlier, the state kept saying, we've given you everything, there isn't anything more. And then it turns out in March, I think February 2022, it's fair to say the state finally admits, or their agent finally admits, oh, there are some more electronic files that we did not disclose to him in 2019.
Let me ask, and I'm sure it's in here if I put all the dates together in timeline. Okay, how long was this delayed because of COVID? And I asked that, you know, there was a period, we shut everything down, then you could open back up, and then we shut everything down again, and then in order to open back up, you had to have a plan. So, which really isn't on the state, so to speak. It's on your local health department and this, that, and the other. So how long was this courtroom shut down that we can give the delay to COVID that has nothing to do with this defendant or the state?
Sure, and we acknowledge that a large part of it was neutral, was how we phrase it, not the fault of the state or the defense. So Mr. Mosley was indicted in October of 2019. 5 months later, COVID happens, March 2020. And then it is not clear from the record what this judicial district's plan was. And then further complicating the timeline in this case is that Mr. Mosley, original attorney, passed away, I think from COVID complications in late 2021. So at least from October 2019 to March 2020, no COVID issue. Then I would acknowledge COVID delays from March 2020 probably till at least early 2021. And then I'm not sure exactly when counsel got sick. That's not really clear of how incapacitated he may have been until he unfortunately passed away in 2021.
And I asked that because, you know, we're now starting to see the speedy trial COVID questions. And as a matter of fact, we had one last month where same argument, but it was out of Shelby County, and the record was completely silent on the fact that Shelby County took forever to get approval to open back up. And, you know, I think that, you know, here it's a delay, and I don't want to discount the delay, and I don't want to discount your client's anxiety and the fact, but you have 2 major events, which there's nothing the state can do about it. And you kind of remove those 2, and it seems like you kind of have a normal timeline for a trial of this magnitude.
And I think that's why the length of delay is just one of the 4 factors, and we acknowledge that. To the extent that that factor is neutral, it certainly, I don't think, is the fault of the states, and we've not alleged that, but that is just one of the 4 factors to be considered. So even if you take out those reasons for the delay, and you just focus on the time where COVID is not a factor, and the attorney's death is not a factor, what really builds to the prejudice for Mr. Mosley, especially as a pro se litigant at that time, was his knowledge that there were files that the state was saying, we don't have them, those don't exist, and he knew they did, and in fact, they were proven to exist. That was the issue there. And also for him, again, as a pro se non-lawyer, he's trying to balance his right to a speedy trial with his right to a fair trial. So he's trying to get the trial court
But doesn't that, I mean, that's part of the risk you run too. I mean, that reason we're very cautious about letting individual act as their own attorney is because we hold them to the same standard we're gonna hold you to. And, and we make that very clear to them. So he made that decision with the approval of the court, but he made that decision, I wanna act as my own attorney. You know, we don't give you credit for being anxious about coming to argument and saying, well, it's okay, we'll go ahead and reverse this because counsel was a little nervous at argument. No, I mean, you either have it or you don't, and we make the decision based on the law. Same thing here, right?
Sure, I think that's true, but in his case, where he knew that there were files that the state was not turning over, and that we're talking about the initial electronic disclosure in 2019 after indictment. And it's not until February 2022, after multiple filings that he's doing on his own, saying, you have to turn over all of the evidence. And the state is saying, we did. We gave you everything.
So speak to the prejudice. You were getting to that.
Yeah.
You said that it was your client's anxiety and what else?
And so the two that we're relying on is the anxiety and concern of the defense and the possibility that the defense is impaired. Now, I acknowledge the missing photographs did not ultimately end up coming in at trial.
Yeah, so that's why I was kind of
that is
confused
true.
about your argument.
Yes.
Clearly, the anxiety is something that is attendant to every person who is charged with an offense, especially something as serious as this.
Of course.
The latter is, you need to expound upon that for me.
Yes, Your Honor. So you have a pro se defendant who is saying, there is additional evidence. I know there is. And you have the state in open court at these motion hearings saying, we've given him everything, Your Honor. There isn't anything else to give him. Essentially, he's crazy. We don't know what he's talking about. And it's not until February 2022 that the state's electronic discovery or forensic analyst says, oh, you know what, he's right. There's a whole type of file that my program didn't discover. So all that time that he's, I'm not to say banging his head against the wall, but insisting and filing motions and saying there's more, there's more, there's more, I want to defend myself, I need everything, and the state is saying, get out of here. Well, it turns out he's right. So that our argument is that is the prejudice there, that I recognize those photos, those videos did not ultimately come in as evidence, but you've got someone trying to represent himself who's lost his attorney to an untimely death.
But that goes back to my point. So if it were you or someone from your office saying, hey, turn this over, we know it exists, we know it exists, we know it exists, and the state says it doesn't, and then says, oh, wait, yep, we missed it, and gives it to you, and then it doesn't come in, how is your client, I mean, again, a pro se litigant is standing in the same shoes as you are, so why should we wouldn't give you a break. We'd say, well, where's the prejudice to your client? You asked for it, you got it, and then it didn't come in. Why is it changed just because it's a pro se litigant, which we say we treat you the same way we treat a seasoned trial attorney? Sure,
I understand, Your Honor. And I think what I'm asking the court to focus on is not necessarily any prejudice at trial, but the pre-trial preparation. And I recognize we treat pro se defendants the same, but that's the point that I wanted to emphasize here, to remind the court he was pro se at that point. And it's just different, for lack of a better explanation. But we're not necessarily worried about prejudice at trial, but that pre-trial preparation.
Is there a case that you want us to rely on in viewing the pre-trial prejudice, or just general?
Sure, I think that is the basic rule for prejudice. The rules that, the cases that we have cited speak to the reasons for the right to a speedy trial. One is to minimize the anxiety and concern of the defense, and one is to limit the possibility that the defense is impaired. Those both are pre-trial, in our opinion.
I got you.
Thank you, Your Honor. Moving to the second point I wanted to address today, which is the self-defense argument, which I think is probably where the court may spend most of its time. Our position is that the trial court erred in making a credibility weight assessment of the proof before simply finding whether the issue of self-defense was fairly raised and then submitting that issue to the jury. That is what this case comes down to. Did the trial court overstep its role as the gatekeeper in not giving a self-defense instruction?
I agree. That's probably where we're going to spend most of our time. What's troubling to me in this case is that the proof, two things. First of all, what I read was the victim was stabbed 40 times.
Yes, Your Honor.
It's hard to make a self-defense challenge with 40 stab wounds. Second, the defendant's statement, which,
Nothing, I'm sorry.
yeah, I mean, the defendant's statement, and I can't remember if this was from the actual written statement or whether this was, did he testify at trial? Was very confusing and rambling in terms of when he actually invoked a self-defense, I guess, defense. So those are my two concerns, and I'm going to give, I'm sure you know that that's where we are based on the briefs.
Yeah, just to kind of go with talking about the second part of what you just said, I mean, the defendant, as I read the briefs, made numerous statements about he didn't remember anything. It's kind of hard to claim self-defense if I'm also claiming I don't remember anything. So I don't.
And this is understanding, and I know you cited, both briefs are very well. We know what the trial court's role is, and they're not supposed to really prejudge facts. It's just, you know, a fair inference that the defense is raised, rather. So, so I'm not going to cut you off anymore, but those are my concerns.
Yes, Your Honor, I acknowledge that. I think my answer to both of your concerns is probably going to be the same, that those are for the jury to decide. I recognize the number of stab wounds. I recognize that his testimony was a little bit all over the place. And part of that, again, was he was pro se and was sort of directing himself at one point. That's kind of, I'm not sure if that's clear from the record, but it is a little bit hard to read.
There should be something there for the trial court to say, I'm going to give this instruction based on something.
Correct. And the something there is his testimony, I was defending myself. This started with me defending myself. And he does say at one point that he was not scared yet. So if you look at the testimony, and I would encourage the court, read it a couple of times because it is kind of jumbled, but he does testify that when he was not scared for his life was earlier in the day. They had fought, they had resolved whatever that issue was. He absolutely testified that he was scared, that he feared for his life, that he was defending himself, that she had a knife in her hand. I think he says that, I cited 2 pages, page 180 and 189 in the record, where he says she had a knife in her hand, not just she was going for knives. That's the testimony, in our view, coupled with the physical proof not contradicting that in any way. There was no, it wasn't that her fingerprints weren't on the knives or anything like that to dispute what his testimony was. So his testimony fairly raises the question of self-defense. The trial judge, at the end of the proof, said that it was on the fence about whether to give the self-defense instruction. It hears the state's rebuttal proof, which is only, well, he didn't claim self-defense in the initial police interview, and then the judge says, well, I'm not giving the self-defense instruction. I'm not sure that's directly tied to the rebuttal proof, but it sounds like it to me. And our position is that rebuttal proof, just because he didn't say self-defense in the initial police interview, does not change the fact that self-defense was fairly raised by the proof presented at trial. That should be the relevant part that we are looking at. And then the trial judge essentially is taking away from the jury the ability to assess whether they believe the self-defense argument. Maybe they don't. The jury's free to accept or reject it. We acknowledge that. But the trial judge's only role is to give the instruction if it is fairly raised. The trial judge certainly was on the fence about it. The state, when you read the closing argument, the state talks about self-defense quite a bit, as if it was actually an issue. But the jury doesn't then have that instruction on how to consider it. So you have the proof that's raised, you have the state's argument about sort of encouraging the jury not to find self-defense, but they've not been instructed on what that would even mean. And so our position here is, while he was indicted for first degree, they convict on second degree.
So, I'm sorry for cutting you off.
It's okay.
Did he argue self-defense, even though it wasn't given as an instruction? What was the state responding to?
I think that, if my recollection is correct, Your Honor, the state's argument, I don't want to misstate anything, but I don't remember the defense argument focusing on self-defense. It may have, But I know that the state's closing argument did. And so again, I go back to it, why is it even being argued if it's not supposed to be an issue? It's because frankly, it was an issue from the proof.
Well, I mean, just because it wasn't given as an instruction doesn't mean you couldn't argue it. So, that's the only reason that gives me, I mean, obviously, the instruction is helpful, and it gives the jury guidance. But when you said the state focused on it, that made me think that he may have injected it more so than what, I guess, his statement, and anyway.
And he may have. I honestly cannot recall, Your Honor. I guess my point there is, it's raised certainly in his testimony, so it is fairly raised by the proof at trial, in our view. Trial court does not instruct, then possibly the defense, certainly the state, focus on self-defense, or at least mention it several times in closing argument. What does the jury know to do with that? And our position is, maybe they don't come back on the lesser included of second, maybe they acquit if they believe the self-defense argument. Maybe they don't, but it is the jury's question to decide, not the judge's. If there are no further questions, I'll reserve the rest of my time for rebuttal. Would ask the court to reverse.
Thank you.
Thank you.
May it please the court, Brent Cherry for the state. Again. Let me jump right into this. First of all, addressing the speedy trial issue. I think the court has already recognized where's the prejudice here in the delay. I tried to lay out in the state's brief the trial court's efforts to figure out, hey, what has actually happened in the chronology of this case? And of course, COVID played a big part. The death of defense counsel played a big part. There were requests for continuances by the defense. There were delays by the state. It went on for a long time. No indication that there was an improper delay in this case. I mean, with the issue with the evidence that the defendant wanted to get hold of, I mean, there was an honest issue with some of the state software as they examined the evidence that they had. They had everything before them. They were trying to figure out how to get into it, and I'm not a software genius, but they were trying. They did the best they could, and then they finally figured out, wait a minute, some of the software that we have, that we use, isn't delivering everything up, and there is something there. And when they brought it up, they delivered it to the defense, and then the defense didn't use it. So when we talk about the prejudice here, after we get through the delay and COVID and the death of counsel and everything else, how did this hurt the defense? And I'm sorry, but I don't see any answer by the defense about how this hurt them. The anxiety to the defendant.
I was going to say that their argument's not so much that it hurt him at trial. Their argument is that it goes to the minimizing the anxiety and the concern of the accused and limit the possibility that his defense will be impaired. They're not saying that necessarily at trial he was actually prejudiced. They're saying he was prejudiced pre-trial in trying to get ready for trial.
Well, again, Your Honor, I just don't, the court obviously didn't buy that argument, and I don't think it has merit. First of all, when we talk about the anxiety, I mean, that's just an issue, as the court's already noted. Everybody has anxiety. I have anxiety coming here, and I don't think you're going to cut me any breaks for the arguments that I make. But certainly, somebody who's facing a first degree, or the possibility of a first degree murder conviction is going to be anxious and concerned. But at the same time, they want to have every avenue developed and every possible defense explored. So that's just going to happen in any case. When we talk about pretrial preparation, the fact that they didn't have something that was never going to deliver anything, that wasn't going to be useful to them, we still have the issue of where is the prejudice? There's a delay, some anxiety with the delay. How is that really prejudicial to the defendant? He's going to be in prison for the next 25 years. He's starting to serve his time. That's going to count. Where's the
Whether it
prejudice?
produces something that I can use at the end of the day is not necessarily relevant to the question of I'm sitting here, I'm fighting for my life, and I'm trying to prepare a defense, and I know something exists, and you're not giving it to me. I mean, that's what I think they're arguing is goes to the anxiety question is here's an individual who's fighting for their life, and they know something exists, but they can't prepare their defense, and whether, when it turns up, they can use it or not is kind of irrelevant to the initial question, is it not, though?
Well, perhaps, but again, we go to the point of, he thinks something's there. I mean, is it just a simple fishing expedition? He was there, he killed this woman, he should know what happened. Is there something on a tape somewhere, some record of what happened that he thinks is gonna help him? He would know what it is because he was there. And in this case, this particular case, when it was finally delivered, big surprise, there was nothing there that helped him. He had counsel to advise him and counsel him about what happened and how's that gonna play in, what's important, what's gonna make a difference in this case. There simply wasn't ever anything there. So it's hard to argue that there was any prejudice. Now, if I may, let me move on to the self-defense instruction issue. The defendant argues that self-defense was fairly raised by the proof and the jury should have been instructed, but the trial court declined to give the instruction because the defendant failed to show that he had, quote, any reasonable belief that he was in imminent fear of death or serious bodily injury at the hands of the victim, unquote. And the court looked at the Benson case, the Supreme Court case that talked about the self-defense instruction in a case where a man was basically kind of slapped around by a woman, and then he shot her to death. And he wanted to argue, hey, I was acting in self-defense because this woman was slapping me around, and in self-defense, I pulled my .45 and put a big hole in her. That doesn't work. And the court looked at this case, and what did he find? He found this, I think she was 5'9", 125 pounds. The defendant was, I believe, 6'2", 185. Pretty significant difference. The fact that he's a male, and although some people may argue with this, men have a different composition.
Aren't these things for the jury to decide?
Well, they are to a degree, sure. Yes, Your Honor. And you know, if
that's
it were,
what troubles me about this case. I mean, I know you're citing Benson, but you know, we're often in this position where, you know, just a little bit, you know, now we're in a position of potentially, you know, having to do it all over again because just one little piece of this, where the state's proof appears to be overwhelming, and that one little piece, you know, is potentially putting the victim's family, everyone, having to do it all over again. And that's what bothers me because the facts are arguably there is that little piece there that could have supported an instruction, you know, and the jury could decide it. All of these factual questions, and that is troubling to take that away from the jury in this process. And I know you're going to cite Benson to me again, aren't you?
well, Your Honor, honestly, I have to say, I'm not unsympathetic to the plight of a defense counsel. I was a defense counsel many, many years ago, and I think the fact that I was on the other side of the room in these cases gives me some degree of temperament when we deal with these issues. But I agree with you to a great extent, Your Honor. I think if there were something raised, why not put it out there? Why not let the jury look at it? But it sounds like the jury was looking at this anyway. In this case, there was a lot of discussion about self-defense. Of course, the defendant said, "Hey, I was scared." Of course, this was after.
But the jury wasn't told they could find self-defense.
They weren't told how they could use it.
Yeah.
I mean,
that's right.
and that's part of the problem. And I haven't reviewed this record in detail. So if her argument, the defense appellate counsel's argument was that the state's responding to self-defense. If that is out there and it's being argued, then by golly, you know, the jury doesn't know what to do with that. That's a problem. Don't you agree?
Well, Your Honor, here's what. Let me kind of lay this out in a perhaps a different fashion, because we have as a prosecutor, we come to the courtroom, we lay out the evidence for the jury to examine and make a decision. We give them instructions. And we try to give them instructions that apply specifically to this evidence. When we're talking about the self-defense instruction, we're talking about not simply was he afraid, but did he fear imminent death or serious bodily injury at the hands of this woman? And when we talk about the whole idea of the Benson case, and is it comparable to this case, we're talking about the fairness of giving this instruction in a situation where the jury might misconstrue the evidence and say, hey, if he was afraid that this woman might slap him, then maybe he should have been able to take the gun and shoot her. Or in this case, where there was no evidence that she did anything more than tout some language and maybe go for a knife, that he could stab her 40 times. So, yeah, I mean, I really get it, Your Honor, and I understand. I'm very sympathetic to that argument, but at the same time, when we look at the Benson case and its application, I don't think we can really say that the court was off base in saying, no, based on Benson, I don't think this is warranted under these circumstances. Now, the state goes on and they talk about self-defense in their argument. That's not hard to understand, because juries are oftentimes unpredictable. They do things we might not expect them to do in light of the instructions, but sometimes it's instructions be damned, the jury's going to do what the jury's going to do. So with all that, was this an abuse of discretion by the court? I don't think so. The way the law reads, the way the circumstances of this case were, the way the facts were laid out, I don't think that's an abuse of discretion. But even if this court were to determine that it was, let's look at whether it would have made a difference in this case. And I don't think that's important, because here we have a case that was there really a possibility that the court could or would have come back with self-defense. Would a reasonable juror find self-defense in this case? And again, we look at the size difference, the male-female difference. We look at the circumstances here where there's no evidence that this defendant has suffered any injuries from this woman. He was a bloody mess. He cut his own trachea in an effort to kill himself, but there was no evidence that she hurt him.
Mr. Cherry, were there any other injuries to the defendant that were documented by the officers? I know his throat, he slit his own throat.
Not that I found in the record, Your Honor. I went looking pretty hard.
I know you did.
The only way that could possibly be construed, he talked about the first cut. And it's not 100% clear whether that meant he cut her or she cut him. I think it's he cut her. But that's the only thing out there that I think can possibly, in anybody's imagination, be construed as she hurt him. And the fact that he cut her 40 times, and not just with one knife or one razor, but with multiple instruments. And we talk about the photographs. That's something we'll leave for the briefs today. But in the photographs, you see a couple of knives, a razor, and right there. I mean, this woman, we're not talking about one stab to defend myself. We're talking about her lungs were punctured, her stomach was punctured, her heart was punctured. I mean, she was really hurt in a violent fashion. There's no way in the world that a reasonable juror would find self-defense under these circumstances.
Well, since you brought it up, I want to talk about photographs for a second. And not the crime scene photographs. There's no question, no matter which story you look at, the state's version, the defendant's version, that this individual was alive at the time of the murder, correct?
Correct.
Why in the world, why does the state continue to present photographs of individuals in their cheerleading outfit? There's no reason to do it other than to gain sympathy with the jury.
Well, Your Honor,
because there's no question she was alive, so I don't need to prove she was alive, because the defendant admits she was alive, because even if you want to believe everything the defendant says, he was acting in self-defense because of the person who was alive tried to kill him. So what's the point of that picture?
You know what, Your Honor, I'm going to be very honest with you. I'm going to step out on a thin branch here and say, I don't think that there really is a super good reason for having that photo in the record. But, by statute, life and being photographs are admissible in homicide cases, and this is the quote out of the statute, when offered by the district attorney general to show the general appearance and condition of the victim while alive, unquote.
Why
And
is that relevant, though? Why
Why-
is that
why is it
relevant in this
relevant?
case?
You know, why is it relevant? A person alive in their normal condition, the way they were, what's the loss, what's the damage, what's the crime? I think that all becomes relevant to that point. You know, is it really relevant to show that he killed her? Perhaps not. But we've got this picture of her as a living being, and then we've got the crime scene photo of her, where if you could wipe away the blood, she would look the same.
Was she in her cheerleading uniform when she was
wasn't in her
murdered?
cheerleading uniform. She was in, you know, some comfortable attire. But the fact is that she appeared the same as a young, attractive woman who suffered serious.
I understand,
extremely
and you know
repeatable-
I've made the same argument you're making, but it bothered me then, and it still bothers me now. I just don't see where it's relevant.
And I agree, I'm not gonna, you know, lambaste you or anything, because I know you're in a tough spot. But I do respect the fact when the state concedes when there is error. And the defendant did not dispute, there is no relevance for that photograph, which only invokes or inflames the passions of the jury when they see the victim in cheerleading attire like that. So, I mean, conceding when it's inappropriate or improper would help send a message to the DAs who are prosecuting these cases. You know, we're not going to go ahead and make a predetermination on the issue, but and I'm not going to force you to concede that it was not relevant. But you've seen us have to grapple with that issue quite frequently, and the state refuses to, you know, stop doing those things. So anyway.
Yeah, Your Honor, if I may just speak to that just briefly, because I do have a great sympathy for, you know, the position of defense counsel and with regard to an issue like this, because there is limited relevance. But at the same time, I think it's fair to recognize that this was a living human being that had a life that was ended prematurely. You know, and by statute, the state is allowed to do this, and I
Only when it's
I agree.
relevant, only when it's relevant. And it wasn't in dispute. I don't want to get excited here, but I mean,
Sorry.
let's just leave that alone, because there was no dispute that she was alive prior to her death. So the analysis goes to relevance. And then it goes to whether it would improperly influence the jury. And clearly, in this case, because she's in her cheerleading uniform with her hands and a beautiful smile.
Yeah.
I mean, I don't know if the victim's family is listening to this. So we, you know, just in respect and deference, you know, sure, she was alive, but you're balancing that with the fair trial rights of the defendant, and you've invoked your prior defense lawyer hat in this case. And we just need to leave that alone, and I'll give you that. Let's just leave that question alone, but understand, Judge, you started it. You started it. And then Judge Dyer picked up
I
on
barely
it.
opened the door, Your Honor. But may I just also point out that, you know, her cheerleading uniform, whether she was in a cheerleading uniform or the dress she wore before she went to church, or the regular attire she wore before she went down the street to go shopping, I think much is made of her role as a pom-pom girl, and I guess what I would say, so what? And is this something that's prejudicial enough to have a bearing on this case? And it does not. Again, this is a young woman that was brutally killed, and shouldn't have been, regardless of what other circumstances she may have brought upon herself. It was just, this is nothing that can be justified, and the court properly found this defendant guilty based on the evidence presented.
Thank you, Mr. Chair.
A couple of quick points, Your Honors. First, I want to distinguish Benson, if I may. As the court brought up, that was, or the state may have brought up, I apologize. In Benson, we have a woman insulting the man, punching, hitting, slapping him in the face, and his response is to shoot her multiple times. Respectfully, not to minimize the death of the victim in this case, that's not what happened. By Mr. Mosley's account, this was a knife fight. There were multiple knives on scene. The physical evidence does not dispute his testimony about how the interaction happened, and he repeatedly testified that he did not start the incident. So respectfully, it is different from Benson. The second point is that, again, if the jury's looking at self-defense, it needs to know what to do with it. And I think I made this point earlier, but I want to reiterate it if I didn't, or in case I didn't. But maybe they convict on second degree because they believe the self-defense theory, but they weren't instructed that if they believe the self-defense theory, that's an acquittal, not a reduced charge. That's where that harm comes in on the failure to instruct. The third point is more of a factual issue. Judge McMullen, to your question about the other injuries, Exhibit 13 in the record is a torso. I think if you're sort of flipping through or you're assuming that it's the victim, it's not. Exhibit 13 is Mr. Mosley, and there was testimony, I just checked, we referenced the citation in our brief, that his other wounds, he had other wounds to his stomach and wrist area. So that it was part of the proof. Exhibit 13 is his stomach area showing those wounds.
Do we know from the proof, I mean, he clearly tried to kill himself, so
Correct.
when you said wrist, do we know that whether he inflicted those
We
wounds?
do not, Your Honor.
Okay.
To be fair, we don't know how those wounds were inflicted, but to your point, they do exist. And the last point I'd like to make, unless there are any questions, I don't think I need to talk about the photograph thing. I was going to point out the relevance, despite, even with the statute, that is the question that the court obviously is more than well aware of. But if I could conclude on the question of whether there is reversible error here. The state talked about it's just not prejudicial enough. And that's where our cumulative error argument comes in. That's where we reiterated that the instructional issue is a constitutional issue. We cannot have just minor harmless errors accumulating and there's no penalty for it. There's no message to the trial court, you need to instruct the jury. There's no message to the state, you need to stop introducing this evidence. And so our position is the piece that's missing here is his right to a fair trial. Again, not to diminish what happened, not to diminish the facts of this case, not to diminish the stab wounds, but if we continue to find errors harmless, whether individually or cumulative, we will continue to see these same problems over and over again. We would ask the court to put a stop to that and reverse for a new trial with a properly instructed jury.
Thank you, counsel.
Thank you.
I think we're going to take that case under advisement as well, and I think that concludes our morning docket. So we'll be in recess until 1:30.